My name is Laurence Gendelman. I'm the president of Gendelman Law Group, and Gendelman Law Group is a firm in Denver, Colorado that does probate, trust, estate, digital asset, and family law. Today, we're here to talk about it's going to be the second set of tips on how to save money in your family law case. If you haven't already done so, you should make sure you watch the first video with our first 3 tips on how to save money in your family law case. And also, please follow us on Instagram, YouTube, and Facebook, and our handle on all those platforms is Gendelman Law. Here today at the Colorado State Capitol, where I'll be speaking. You have to click with your lawyer. When you meet them, there should be...
So one of the ways that I give back to the community is by educating people about the ways that they can understand the role of their lawyers.
All right, so we'll just dive right into it. Tip number 4. Check your email as a client and respond daily. So when you're dealing with a family law case, you're going to have a lot of communication with your lawyer, with the law firm staff members, and you're going to go back and forth about lots of different issues, whether it be financial disclosures, parenting time issues or disputes, settlement offers with the other side, etc. If you have, let's say, an expert that's been appointed on your case or some other professional, they'll probably be emailing you as well. And they're going to want information and regular updates as to what's going on. Especially when you're dealing with an expert and you're emailing, you want to be prompt with them. Their opinion of you and how prompt you are and how well you're responding to their communications could have an impact on your case. For example, if you have a child family investigator that's appointed in your case to determine parenting time, that person wants to see that you care and that you care about your kids and you care about the outcome of the case and that you're promptly getting them information about your kids, getting them the release forms they need that they can talk to the appropriate people. They're essentially evaluating part of your parenting ability in a lot of cases. They're not going to tell you this, but based on how prompt you are and your ability to follow their instructions, follow the directions, meet the dates, and meet the deadlines. If you're waiting a week to get information back to a CFI about your own children, it generally doesn't look good. Failure to review your emails in a timely manner also will result in an increase in your bill. So if a week goes by and your attorney or their office are waiting on a document, let's say a financial disclosure that's really important that has to get filed with the court or given to the other side, if the staff have to continue to follow up with emails for you, you're going to be charged, as you know, for the time for each of those emails you have to send. So if you're responding quickly and promptly, it will also help to keep your bill lower. All right, so tip number 5 is to start your financial disclosures early. So if you're in a family law case, you probably already know that there's all these really annoying disclosure requirements, and part of it requires you to get some taxes, pay stubs, bank statements, investment account statements, perhaps your insurance policy. And a lot of these requirements are true for both divorce cases and when you're unmarried and you're just dealing, let's say, with a child support issue or you're dealing with a modification of child support. So the reason that you have to do these disclosures, which again are onerous and can be obnoxious, is because we have to figure out what those numbers are. In the divorce, it's who gets which assets, who gets which debts. If you're dealing with child support, it's how do we calculate the right amount? Is one party paying for health insurance or reasonable daycare expenses or some kind of extraordinary expense? All those go into the formulas and the way that child support is determined. So it is annoying to deal with financial disclosures. You'll have to get bank statements and tax returns and credit card applications and all sorts of information, perhaps back to 3 years. This is the number one area where clients' fees will just get out of control. It's the top area where people don't need to spend money on legal fees, but they do because it's difficult for them to get this information on their own. So you're going to get a list of documents in the beginning, what you need in order to in order to meet the requirements of your case. And in Colorado, these are called generally the 16.2 disclosures. You have to get them. For the most part, your attorney can't do it for you. You have to go to the bank and get bank statements. You have to go to your investment company and get an investment account statement. You might have to go to your insurance company and get an insurance policy document. if you have questions about what you have to get, it's important to schedule a call with your attorney to find out. But once you know, at that point, it's the client's responsibility to get those documents. My suggestion is to take 1 or 2 days, weekdays off of work, and use those days to get all the financials together. If you need to make requests to the IRS for tax transcripts, that's your time to do it. If you have to go down to H&R Block and get copies of previous tax returns, that's your day to do it. Because a lot of these documents you need, you might have to deal with someone during business hours. So people obviously don't want to take off work because they lose money, but you will save money doing it that way, taking your 1 or 2 days of work off work and saying, I'm going to get all my financial disclosures together. Then if you try to piecemeal your financial disclosures over some period of time and have a lot of emails back and forth between you and the paralegal or the lawyer or the legal assistant trying to figure out what you might have, what you might be missing, and how you should go about getting those documents. For the most part, the law firms can't really help you get the documents in any kind of easy or cost-effective way. If the firm has to, it's expensive. It can involve getting subpoenas. It can involve having releases signed. It can involve a lot of extra communication that's unnecessary that can be solved by the client just driving down to the bank and getting the documents. So most clients will also wait until, let's say, the week before disclosures are due to actually start the process. Start the process immediately, right when you file, right when you're served, right when you meet with your attorney. Get going on your financial disclosures, because a lot of the documents you'll have to request and then wait. You'll have to wait for an institution to get you what you need. If you don't meet the financial disclosure requirements in time, the other side of your case can file in Colorado what's called a motion to compel to try to force you to give over those documents. If that has to be done, you can be responsible for paying the other side's lawyer's fees because you failed to get the documents in time and they had to file a motion with the court to force you to do it. The last thing that anyone wants to do is have to pay not only their own lawyer fees, but the other side's lawyer's fees, and then also have to pay their lawyer's fees for defending a motion to compel. It could be thousands of dollars that can be solved by taking a trip down to the bank or taking 1 day off of work to get all your financial disclosures together. So once you hire a lawyer, or once you're served, or once you respond to a motion, that's your time to start your financial disclosures. All right, so 6th tip today. So you're getting all your financial disclosures together, right? And you log on, let's say, usually to your bank account on your phone. And you can see a screenshot on your phone of your Wells Fargo account balance, or your investment account balance, whatever it may be, and you take a screenshot, you send that to your lawyer. That's not a statement. That screenshot does not meet the financial disclosure requirements. Attorneys can't use screenshots from phones to make a good financial disclosure. It's generally incomplete, and it doesn't contain all the information that's necessary. I can tell you that I've had clients who have sent screenshots of statements, and maybe it's several pages long, so they'll have 10 or 20 different pictures that, when put together, all make up one statement. That might be a statement, but understand that when the attorney or the legal assistant gets those pictures, they're gonna have to work on their end to convert them to PDFs, combine them into files, optimize the images, rearrange where the pictures are, and make it into an actual statement. They might have to also then clip information that's duplicative from picture to picture. That's time, and you're paying for time. So that statement that you just made with a series of pictures might cost $100 or $200 for someone to sit there and assemble for you, when you could have just signed on to your account, downloaded the statement, and emailed it to, signed on to your account online, download the statement, and emailed it to the law firm. It's a way to easily save costs by just doing things right the first time. But screenshots are not financial disclosures. In addition, when you're using screenshots in place, I guess, of a financial disclosure, it doesn't look good and doesn't look particularly professional to your attorney or to the other side or the other side's lawyer or to the court. Screenshots certainly do have their time and place, and that often will be text messages between you and your spouse or you and your ex. But when it comes to financials, they're really not appropriate. So thanks for tuning in today to hear about our second half, or it's not, I guess it's not second half, but our second in a 3-part series of how to save money in your family law case. Be sure to subscribe to our Facebook channel, our Instagram, and YouTube. And again, our handle is Gendelman Law. And we'll also link our social media to this so you can stay in touch with this video. And again, my name is Laurence Gendelman with Gendelman Law Group, and we'll see you soon. Thanks.